Chers amis, mesdames et messieurs, bonjour. It is once again from Baton Rouge, Louisiana, that I deliver my short presentation. I'm very sorry to miss our meeting once again. This is a very busy time at Louisiana State University. We have foreign visitors. We prepare for the arrival of students and professors from Haiti based on the relief effort that I'm coordinating at LSU, and I had a number of commitments precisely that week after Easter. My wife Marie-Antoinette joins me to express best and warmest wishes to our dear friend Professor Helmut Koziol and his dearest wife Cornelia on the occasion of Helmut's very special birthday. Joyeux anniversaire, lieber Helmut. Helmut likes to joke on the creativity of French tort law, especially some of its unreasonable developments. The year 2009, otherwise rather dull, offers a good and entertaining story. French people, like everyone, everywhere in the world, spend hours talking and texting on their mobile phones. The entire population is covered with over 50,000 mobile phones, phone relay antennas all over the country. It is good business for owners of tall buildings. And priests welcome antennas in the clocher, in the church towers, using the income to maintain these costly buildings and maybe requesting electronic prayers. When there is no church nearby, use is made of other tall buildings, such as residential structures. Yet some people complain that they may be subjected to the undesired effect of unsolicited radiations that may affect good health. In European Tort Law 2004, I presented a case where the Court of Appeal of Aix-en-Provence affirmed a judgment ordering the removal of an antenna that stood nearby an elementary school. Several judgments were rendered in 2009 ordering the removal of antennas, this time in residential areas. Here is one of them. Some resident of Tassin-la-Demi-Lune, a posh suburb of Lyon, sued Bouygues Telecom, arguing that the presence of a nearby antenna caused a nuisance, exposing their health to a possible risk. No alteration of health condition was alleged, except some anxiety caused by the vicinity of the antenna. In a judgment of September the 18th, 2008, the Tribunal de Grande Instance of Nanterre ordered the removal of the antenna. The court cited dubious sources whereby some French and international authorities recommend applying the precautionary principle. There is no harm, said the court, but there is a risk of harm, and this risk is certain. This certain risk is described as an abnormal disturbance because it is a risk to human health. No fault, no violation of laws or regulation is requested in French law for a trouble de voisinage or nuisance to exist. It is indeed to be noted that the defendant was in full compliance with all applicable regulations. Well, the court reasoning is circuitous. No harm, but the risk of harm, described as certain since the precautionary principle applies to prevent risks that are not certain, and an abnormal disturbance since this is to human health, a challenge to common sense and sound logic. All this in the country of Descartes. In addition, the onus of evidence is shifted to the defendant, who would have to prove that their activity generates no risk. Appellate courts were so far more careful in their judgments. They avoided explicit references to the precautionary principle by fear of sanction by the Court of Cassation. The precautionary principle was indeed given a constitutional value by the adoption of the Charter for the Environment, adopted in 2004 and referred to in the preamble of the Constitution. Let me read the preamble. The French people solemnly proclaim their attachment to the rights of man and the principles of national sovereignty as defined by the Declaration of 1789, confirmed and complemented by the preamble to the Constitution of 1946, into the rights and duties as defined in the Charter for the Environment of 2004. Let's visit the Charter. Article 5 reads, where the occurrence of damage, though uncertain in the state of scientific knowledge, could affect the environment in a serious and irreversible way, public authorities ensure, by applying the precautionary principle in their areas of responsibility, the implementation of risk assessment procedures and the adoption of provisional and proportionate measures to prevent the occurrence of the damage. Well, does this apply to a hypothetical risk to health caused by mobile phone antennas? Are we dealing with environmental risk that could affect the environment in a serious and irreversible way? It is doubtful the court would uphold the precautionary principle in a non-environmental dispute. In addition, the Cour de Cassation so far refused to compensate purely hypothetical damage. The Court of Appeal of Versailles, on appeal of the case at hand, judgment of February the 4th, 2009, based its decision on the French doctrine of troubles anormaux de voisinage, or nuisance. The court rendered an affirmative judgment, yet using different arguments just to make the judgment bulletproof, or Cour de Cassation proof. First, there may be nuisance, even in cases where the defendant acted lawfully, in full compliance with existing regulations. This point cannot be challenged, but one feels uneasy where the court insists that some foreign regulations are more stringent than the French. I'll come back to this. Secondly, the court notes that the risk, though hypothetical, is reasonable and serious. The defendant should have taken steps to reduce such risk. Connected to the first point, this creates the impression that foreign regulations should be given precedence to French regulations. Thirdly, the court says that given the fact that having no guarantee that the antenna does not cause risk, the victims have a legitimate fear. This legitimate fear is to be regarded as a disturbance. The fact that there is fear of a sanitary risk makes the disturbance abnormal. The only way to cure the damage, characterized as the anxiety generated by the risk, is to remove the antenna. The precautionary principle is hiding between the line. It impliedly supports the judgment. Like in the challenge decision, there is reversal of the burden of proof. The non-pecuniary damage is to be compensated or repaired, even if there is no other damage. Some of my colleagues, of my French colleagues, applaud. Many criticize. With such reasoning in the 19th century, France would be devoid of railroad and electricity. Une exception française? Well, Descartes did not use cell phones. This is a historical fact. Some of you may know that when the activist José Bové had fields of transgenic corn reaped and the corn destroyed, a lower court said that there was no criminal offense. Guess what? José Bové and his supporters had acted in a state of necessity. Coming back to the antennas, nobody checked whether the plaintiffs or their children were mobile phone users. Everyone wants to use a mobile phone everywhere, and nobody wants to face the disturbance. Well, this offers a good illustration of French contemporary society. The French Academy of Medicine declared that a 24-hour proximity with a mobile phone antenna is equivalent to the use of a mobile phone during 30 seconds every day. They concluded that there is no danger. One local court only resisted such claims. Well, it's the Tribunal de Grande Instance de Lyon, my hometown. The Lyonnese are known to be sensible people, except maybe when they migrate to Baton Rouge and miss a Vienna meeting. I will see you next year, and feel free to call me on my cell phone. Thank you.